Rourke versus Rothman.
Mr. Kimmel?
May it please the Court, my name is Kenneth Kimmel, excuse me, and I represent the defendant, landowner Stuart Rothman. All that's in dispute this morning is the meaning of three words in Chapter 48, Section 6, the words, then existing requirements. And in a moment I'm going to demonstrate that the interpretation that we've put forward is the only one that's consistent with the plain meaning of those words, and perhaps more importantly, the purpose of the statute. But if I may, I'd like to digress just for a moment to highlight some facts that I don't believe received the attention they deserved from the Land Court and the Appeals Court. And that is the title history of these lots from 1963 to 1970. In 1963, a woman named Mrs. Morrill owned three lots, the lot in question, Lot 12, and two adjacent lots, Lots 11 and 13. And you can see from the plan that each of those lots was 8,000 square feet with 80 feet of frontage. If you were to aggregate those three lots together, you'd have 24,000 square feet of lot size and 240 feet of frontage, which would have met the dimensional requirements that existed at the time. So one option she had was to take those three lots, combine them, she'd have a buildable lot. She didn't do that. What she did was she sold each of those individual lots off. And the reason, or my inference as to why she did that, is that the bylaw as it existed at the time only required that each of these lots be 5,000 square feet in size.
Can I ask you a question about that, about the bylaw at the time? The 1954 and the 1961 bylaws, they allowed grandfathering or afforded grandfathering if either the lots were separately owned or there was 5,000 square feet. But at the time, the enabling statute, I think, Chapter 48, Section 5, required separate ownership. And it seems to me that Mr. Rothman is relying on the alternative provision in the bylaw, the 5,000 square foot provision, because these lots were not separately owned. They were under common ownership. Why weren't the 1954 and the 1961 bylaws ultra vires of the enabling statute?
Because, and there's some case law that suggests that the 5,000 square foot grandfathering in the state statute is a floor, not a ceiling. The local municipality was always allowed, even under the old Enabling Act, to provide for grandfathering that was more permissive than what the state statute allowed. And so that's why it was permissible for the town to have a more permissive grandfathering. In any event, my thesis is she sold off these lots because the Orleans bylaws that existed at the time specifically allowed these three lots to be buildable at 5,000 square feet, and each of them, of course, exceeded that. So the bylaw allowed her to do exactly what she did, which is to separate the lots, and then in 1970, Orleans changed the bylaw. And the effect of the change was to take all of these three lots that were buildable and now make them unbuildable, because the wording changed in such a way as to retroactively extinguish the buildability of these three lots. My thesis is that Chapter 48, Section 6 was designed precisely to prevent that kind of retroactive extinguishment of buildable rights for single-family homes. And that's why this statute does apply to this case and should have been applied. I'd also just like to point out factually that there's a second element of reliance in this case. This isn't the only time that a landowner relied on Orleans. My client, Mr. Rothman, before he bought this lot, he got not one but two letters from two different building inspectors stating that, in their opinion, under the Orleans bylaw, the lot was buildable, even though it didn't meet the current dimensional requirements. The record is crystal clear that he purchased the lot in reliance upon those opinions. He spent $300,000 and took out a mortgage on his primary home, only after the closing to get a letter from the building inspector saying, "I'm sorry, but I've changed my mind, and Lot 12 is not buildable." He appealed that determination to the zoning board, and the zoning board reversed the building inspector and determined that the lot was buildable, and the intent was to grandfather and to continue to grandfather those lots. And unfortunately, the abutters, who I guess don't want a new house there have appealed it, and they prevailed in the land court and the appeals court.
Can you kind of simplify this for me? The reference to then refers to what point in time?
It refers to the requirements that were in effect just prior to the time that the lot became non-conforming.
All right, so we're going to go back to when the woman owned the property? Actually,
what you do is you take the conveyance that made this a separate lot.
In this case, it's immediately prior to the 1970, your theory is it's
Correct.
immediately prior to the 1970 Orleans change of its bylaw.
Precisely.
That's the point in time.
That's the point in time. That's the point in time.
1970.
And so the question you ask is, as of that point in time, just prior to the change, did this lot conform to the then existing requirements? I think the answer to that is yes. The bylaw in effect at the time is the 1961 bylaw. It's on page 51 of the record appendix. And it says, one building may be erected on any lot which at the time this bylaw is adopted, that's 1954, either is separately owned, this wasn't, or contains 5,000 square feet, this does. So I read the words then existing requirements very literally to mean what are the requirements that applied to this lot just before the zoning bylaw was changed. And if it was buildable at that time, it meets the then existing requirements prong.
Mr. Kimmel, doesn't that mean, I'm really trying to think this through, doesn't that mean that under Chapter 40, Section 6, every single piece of property is grandfathered because you go back to, in perpetuity, because you go back to the moment in time immediately before it becomes non-conforming?
The answer is no, not any property. First of all, any lot that's smaller than 5,000 square feet doesn't meet that. No, but that's an important one. The second one is
5,000 square feet in this day and age is not
small.
Exactly a huge lot.
But the second one that's important is it has to be an isolated lot as of that date. In other words, if I own 3 lots, I have to aggregate them, or I can take advantage of another exemption, which is more limited, the 5-year one. So it has to be isolated. It has to be 5,000 square feet.
No, but that's practically every single piece of property.
I don't know if it is, but let me also respond this way.
Let me put it this way. If what the bylaw is changing is the dimensional requirements to increase the minimum lot sizes.
That's correct. Then it applies. One could be troubled by the policy implications of this perpetual exemption.
I understand that.
But that's what the legislature did. There's been efforts to undo that, to make it more limited in time, to reduce the various grandfathering rules. The legislature hasn't chosen to. And to me, let me give you a hypothetical. Let's say at the time the zoning bylaw was enacted, it was an 8,000 square foot lot size.
Right.
And his lot obviously complies. They change it to 10,000. His lot is grandfathered forever under 48.6. There'd be no question about that. It may be a bad policy to have that forever, and it may be a bad policy to include so many lots, but that's what the statute says. And I see no difference in changing a bylaw to raise the lot size on the one hand versus changing a bylaw to change the exemptions that apply to old lots. The mechanism is different. The effect is exactly the same.
Well, you focus on then, and they focus on requirements versus exemptions. So how about existing?
Well, I think existing is the key word. Here's the real difference, I think.
Well, it's then, he's saying, if it said then existing exemption, I think you would probably, I'm not going to ask him, I'll ask Mr. Kaplan when he gets up in a second, but the then existing exemption, maybe he would agree with you, but he's saying requirements. So, so help me out of that conundrum.
I guess I have 2 answers. First of all, as I read the 1961 bylaw, just as a matter of language, the 5,000 square foot, it's not an exemption, it's the requirement that pertains to pre-1954 lots. You could say, yeah, they're exempted from the 20,000 square feet one. You could say that. You could call it that.
I certainly could.
But you could also say the requirement is 5,000 square feet. That's the then existing requirement. Here's what I think the real difference is between our 2 views. a lot of bylaws have different numerical requirements for different types of lots. Mr. Kaplan and the appeals court are saying, to meet the then existing requirements, you take the maximum dimensional requirement and you ask whether the lot in question met that, and if it didn't, you lose. That's his position. My position is you take the requirement that actually applied to this lot at the time, and if it met it, then it meets it, then it's preserved.
No, I understand.
That's the difference, I think. So I don't think much hinges really on whether you call it an exemption or a requirement.
Well, in essence, that's the underpinning of the appeals court and the land court's analysis. Which
It is.
In fact, you're looking at, I think everybody's looking at the same moment in time, and the question was, will you then cut out, exempted, not bound by the 20,000 square foot?
You could look at it that way. I think the fairer assessment of this is we have a two-tiered system here in Orleans, where certain numerical requirements apply to new lots, certain ones apply to old lots, and I read then existing requirements to mean the one that applies to the lot in question, not some other hypothetical lot that exists in town. And I guess this is where I think the statutory purpose becomes so important, because if you feel that the statute could be read fairly in two different ways, then it's ambiguous. And then the guidepost is, well, what was the legislature attempting to accomplish? What's the purpose? And this Court has articulated that several times. In the Sturgis case and in the Adamowitz case, you said the purpose of this particular provision is to preserve the buildability for single-family residences of lots that meet the modest dimensional requirements of 5,000 square feet, 50 feet of frontage. That purpose is clearly fulfilled by interpreting the statute in the way I'm proposing. It clearly is not fulfilled if you do what the appeals court and what Mr. Kaplan, as they interpret it. And again, I think what's important about this case is not only we have an actual set of facts that shows the landowner relied on the zoning as it existed and made investment-backed decisions based on the buildability of the lots. And that's the purpose of the statute, is to preserve those reliance interests and those expectations. And if you interpret the statute not to apply here, you've really destroyed the fundamental purpose of what the legislature was trying to accomplish. I would also add, and I think these are more in the nature of tiebreakers than fundamentals, there are some other doctrines that fit into the mix here. Another one is the concept of avoiding the retroactive application of statutes. That's a concept that this Court relied on in Adamowitz when it was interpreting this section. If you don't apply 48.6 here, the effect is that Orleans has retroactively extinguished rights after the fact. You avoid that outcome by interpreting the language as we've suggested. The other policy or legal issue is you avoid any claim of a regulatory taking. If indeed...
And we like to avoid those.
It's good policy to avoid those whenever possible. In Adamowitz, you interpreted the statute broadly to avoid a claim of a regulatory taking by the landowner.
But did you raise any takings argument below?
No. Nope, we haven't. My point is more as a matter of statutory construction. If you can construe the statute in such a way as to avoid a constitutional issue, you should.
Well, I assume that if we rule against you, your client can then file as a regulator.
I think he could. And
I don't know what statute.
And the fact that he got an opinion from the town that the lot was buildable would be a factor that would go into the mix of whether he had a reasonable investment-backed expectation that was vitiated by the change in zoning. So I do think that that's important. And I guess the final point I'll make is both the land court and the appeals court seem to rely heavily on this alleged policy of zoning, which is to eliminate zoning nonconformity. And I would agree that that's a general policy, and I know some of the justices in the Bransford case relied on that, others didn't. But for this particular statute, the policy simply doesn't apply. The purpose of this section is not to eliminate nonconformity. It's actually the opposite. It's to perpetuate nonconformity for certain lots that meet those modest requirements. And so I think both the appeals court and the land court erred by taking a policy that may be true of some parts of the Zoning Act and misapplying it to this particular statute in which it doesn't apply.
Thank you, Mr. Camille.
Thank you.
Mr. Kaplan?
Good morning. May it please the Court. My name is Brian Kaplan. I represent the plaintiff appellees in this case. This is a case about statutory interpretation. The statute is the first sentence of paragraph 4 of Section 6 of the Zoning Act, Chapter 40A. The first sentence says that a lot is exempt from increases in dimensional requirements if, when the lot was sold into separate ownership, it conformed to requirements. There are two key words here, conformed and requirements. Now, the legislature distinguishes between requirements on the one hand and exemptions on the other. The legislature treats those two things as different things. It does so in dozens and dozens of statutes across the general laws. We cite them in the addendum to our brief, pages 9 to 14 of the addendum. We give dozens of examples where the legislature talks about requirements, and then it talks about exemptions from the requirements. And more important than any of those other dozens of examples, the legislature distinguishes between requirements on the one hand and exemptions on the other hand in our statute, in Section 6 itself. Paragraph 4 says you had to conform to requirements. Paragraph 8 of Section 6 of Chapter 40A talks about exemptive provisions. There are certain exemptive provisions governing subdivision plans that paragraph 8 says are extended in the event of litigation concerning the subdivision plan.
It's a definition within a definition, because as I read the 8th paragraph, the exemption provisions of this section, which I take it the legislature means Section 6, are correct?
No, it's talking about the exemptive provisions of paragraphs 5, 6, and 7.
It says exemptive provisions of this section?
Sure, but it's talking about the exemptions governing subdivision plans, which are paragraphs 5, 6, and 7. The legislature.
I'll take your word for it.
Okay, but the legislature.
This is a difficult statute to pass.
It is, but.
Well, help me understand this. Back in 1954, when the town adopted a zoning bylaw, it provided for buildable lots that were at least 5,000 square feet, correct?
Correct.
So let's say a person had a lot that was larger than 5,000 feet, and then we fast forward ahead to the 70s, and we look at the language in 40A6. Has that exemption vanished now? Is it gone?
Yes, it has. It has because of the language of the statute, and it has because of the language that the town chose to adopt.
So at one time the lot was buildable, and at a later time it's not buildable.
That's correct. And that's what the legislature wrote, and that's what the town wrote. But look, the purpose of paragraph 4 is not to protect all once buildable lots from becoming not buildable. This court in Adamowicz, in the very first paragraph, wrote that the purpose of paragraph 4 is to protect certain buildable lots from becoming not buildable. And the most simple and obvious example is a lot that is less than 5,000 square feet. The legislature specifically did not want a lot that was less than 5,000 square feet to remain buildable if the requirements of the bylaw increase. We look to the statute to tell us what the purpose of the statute is. First and foremost, this Court has written on numerous occasions, if you want to know what the purpose of a statute is, you look to the language of the statute. The language of the statute tells us that the purpose is not to protect all buildable lots. It's not to protect buildable lots that are less than 5,000 square feet. It's only to protect buildable lots that conformed to requirements. If the legislature wanted to protect all lots that were buildable so long as they were at least 5,000 square feet and had 50 feet of frontage, the language of the first sentence of paragraph 4 would be different. The legislature showed us how it made the issue be whether a lot was buildable. It did so not in the first sentence of paragraph 4. It did so in the third sentence of paragraph 4 and in old Chapter 40A, Section 5A, the predecessor to paragraph 4.
So your view of the statute is that, your view of grandfathering under the statute is that if a lot has once been grandfathered, essentially that's it. You are protected until the next increase in a town bylaw for area, lot area.
You're protected from increases in requirements in perpetuity. But we're not talking here about an increase in a requirement. If we look at the bylaw change, if we look at the bylaw that was in effect in March 1970, when this lot was sold into separate ownership, Mr. Kimmel argues that the lot conformed to requirements. It did not. The requirement at that point in time was that a lot had to have at least 20,000 square feet and 120 feet of frontage.
Or?
Well, the bylaw went on to say, provided that you can build a house if the lot either was separately owned or had at least 5,000 square feet.
Isn't that a requirement that applies to some property, but obviously doesn't apply to other property?
Well, it's an exemption, and the legislature distinguishes between requirements and exemptions, and the town distinguished between requirements and exemptions.
We can call it a requirement or an exemption. That's just a word. They sort of mean the same thing.
Well, it's just a word, but it's just a word that the legislature chose to use. And this Court
did the bylaw choose to use that word?
Sure, by using the word provided. This Court found in the
That's
Sears...
not the same word.
This Court found in the Sears case, Your Honor, that the word provided in common speech expresses an exception from what came just before.
Or a condition, or a...
That's right. But in the context of this bylaw, it was not sort of adding another condition on top of having to have 20,000 square feet and 120 feet of frontage. It was creating an exception. And if that's not good enough, look at the legislative history. The town meeting, which is the town's legislative branch, in 1971, 30 years before Rothman bought this property, it rearranged the bylaw. It took what we're calling requirements, 20,000 square feet, 120 feet of frontage, and it put that beneath the heading requirements. It took the substance of the provided clause, and it put that beneath the heading exempted lots. And this is in the this is in the record, pages 58 and 59. And that same structure has held for the next 35 years. So for the past 35 years, the town's legislative body, the town meeting, has been telling us what came before the word provided were the requirements. What comes after the word provided
So if I
was
go
an
into
exemption.
town and I pick out a lot and I ask you, what are the building requirements on this lot? And this lot happens to be one of those lots that's covered by what you say is an exemption. What would you tell me? Well, the requirements are 5,000 square feet and this, and if you meet that, it's buildable. Isn't that the requirements for that lot?
Well, I would say that the requirements are, for that district, 20,000 square feet, 120 feet of frontage, but the town has created an exemption. And again, the legislature draws this distinction. This is not a distinction that I am manufacturing. In dozens of statutes across the general laws, the legislature distinguishes between requirements and exemptions. In our very statute, Section 6, the legislature distinguishes between requirements, a word it uses in paragraph 4, first sentence, and exemptive provisions, a term it uses in paragraph 8.
What event rendered this lot unbuildable?
The March 1970, I'm sorry, the May 1970 bylaw amendment that changed the word or in the exemption to and, so that as of May 1970, the exemption said provided that the lot, provided that one house may be built on a lot that as of 1954, 5,000 square feet and was separately owned. And
well, in other words, they repealed the exemption, the earlier exemption.
Exactly.
And substituted another exemption.
Exactly.
That's really the heart of the case. Once that exemption disappears, the word requirements mean the new requirements, right?
That's correct. And the new requirements were not satisfied in this case.
Well, the new exemption was not satisfied.
Neither was satisfied. I mean, the old requirements were not satisfied, and the new exemption was not satisfied as of that date.
So I guess the lesson for landowners is if you're subject to one of these things, an exemption, you darn well better build pretty quick, because if it gets repealed, then you could be stuck with the new thing, the new requirements.
But why doesn't a requirement include within it all the exemptions to it?
Because the way I have read this court to interpret statutes over the past decade, and I include a number of sites in our brief, when the legislature uses a term like requirements in one paragraph of the statute, and it uses another term like exemptions or exemptive provisions in another paragraph of the same statute, this court does not read those two different terms to mean the same exact thing. This court also does not pluck the term that's in paragraph 8 of the statute and drag it over to paragraph 4 of the statute and insert it into paragraph 4. And that's basically what Rothman is asking the court to do. This court distinguished in the statute between requirements and exemptive provisions. Those are two different terms that the legislature chose to use in two different places. But Rothman wants this court to read requirements suddenly to mean not only requirements, but exemptions from requirements. And by the way, this characterization of the provided clause as an exemption, it's not just our characterization. I gave you the plain meaning reason for the characterization. I gave you the legislative history reason for the characterization. But Rothman also calls it an exemption. In the brief that he filed with this court, footnote 1, page 4, he refers to it as the 1954 exemption. Later on in his brief, page 10, he refers to it as an exemption.
So if the town in May of 1970 had not changed the word or to and, but instead had further increased the minimum lot requirements up to 2-acre minimum zoning, the lot would have been grandfathered.
It still, under the bylaw, would have been buildable, yes, because so far as the town was concerned, there was that the exemption still would have existed, yes.
But you then have to go to the second sentence of paragraph 4 to see the exemption that the legislature carved out of the first requirement, correct?
The second sentence.
In other words, as I read it, you've got an increase. If you've got an increase in area, so it's also some other increases, frontage, width, yard, and so on. Then the legislature says any increase shall not apply for a period of 5 years. So that's putting everybody on notice. I mean, it's creating its own exemption within its requirement, and then it says, I think it's a 7,000 or something.
Right. The second sentence applies for lots that are commonly owned, that are where you own not only the lot in question, but the neighboring lot. And that, for that sentence, if you satisfy the test, then you get an exemption for a period of 5 years.
Correct.
Only. Correct.
Yes. So that's creating its own exemption, as it were.
In effect, yes. I want to say something about the takings argument and the retroactivity arguments that Mr. Kimmel raises. Neither argument was ever raised below. Not in the land court, not in the appeals court. This is the first time.
We wouldn't decide those issues here. They're just, as was pointed out, they're just factors in statutory interpretation. We generally interpret statutes to avoid constitutional questions. I don't think he's asking us to decide the takings issue.
Well, but he is making the retroactivity argument, and the retroactivity argument was never raised below. And I don't think this statute is retroactive. Or the bylaw in question. He's complaining that the bylaw, the 1970 bylaw amendment, was retroactive. It didn't reach back and say, as of a few years ago, the lot was not protected by the exemption. It says, from now on, going forward, the lot is no longer going to be exempted. And this court has decided in the Merchants National Bank case and in the Commonwealth v. Bruno case, which I cite in my brief, that that sort of situation, even though the the bylaw amendment back in 1970 turned on the ownership status previously, that doesn't constitute retroactivity.
So a town could actually amend its bylaw by eliminating grandfathering altogether.
Well, yes and no. The statute, Chapter 40A, will always
Have a floor in it.
That's right. But the town, through its bylaw, is not required to add additional exemptions or additional grandfathering clauses. It's the third sentence of paragraph 4 of Section 6 that allows towns to do that. And by the way, Justice Spina, the old 40A, Section 5A, I don't believe had that language. So I'm not so sure. The answer to your first question to Mr. Kimmel was the answer he gave, because I think that language was absent from the old statute.
Yeah,
and
about the 5,000 square feet. It was not. I pulled that statute, and I didn't see the 5,000 square feet in it.
I'm talking about the third sentence of paragraph 4 of the current statute, which says that essentially that towns can give more generous grandfathering exemptions than paragraph 4 does. I don't know that there was an analog to that in old Chapter 40A, old Section 5A.
Thank you, Mr. Kaplan.
Thank you.